All right, welcome back. Now, last year, the High Court in Pretoria ruled that the decision to drop the corruption charges against President Jacob Zuma in 2009 was irrational. That meant that the decision to charge the president with corruption will be reinstated, of course, depending on what happens in the next 2 days at the Supreme Court of Appeal in Bloemfontein. Our reporter, Aldrin Sampear, is outside the court and is now joined by James Selfe from the Democratic Alliance. Aldrin, good morning to you, and it's over to you.
Well, good morning, Balisa. As you've indicated, it is the Supreme Court of Appeal case as the application that has been brought by President Jacob Zuma. And the NPA, of course, this time around, unlike back in 2009 and 2008, the NPA is in President Jacob Zuma's corner this time around. But also, in addition, we have the DA who have been fighting this matter since that decision taken by Mr. back in April 2009, literally just days before the elections. And I'm going to bring in James Selfe from the DA now. James, we've spoken about this matter various times, many times before, and you've indicated that it is a matter of principle. It's not whether it is President Jacob Zuma, the president. It's about the principle that there are these allegations against the man called Jacob Zuma, and these allegations should be tested in a court of law. And the DA has indicated that they're willing to go all the way to the Constitutional Court to make sure that the president has his day in court and the rule of law is upheld.
That's quite correct, yes. We've been at this for 8.5 years. We're now at the second last court that we can go to. But at issue here is, as you say, there is one law in South Africa. It applies to everyone, whether you are the president of South Africa or a homeless person. There is one law. He has been charged. A court has found unanimously that the dropping of the charges was illegal, irrational, and has set it aside. The appeal is now being heard, but if we win, then as far as we're concerned, Jacob Zuma is an accused person, like everybody else would be an accused person, and he must be summoned to a court and indicted accordingly.
Certainly not the end of this matter, because even if you look through President Jacob Zuma's court papers, they argue this issue around should the NPA decide to uphold and implement this decision by the High Court, that will give rise to an application for a permanent stay. Would the DA then also be involved in such a matter?
Well, of course, because really the issue is one of principle. The issue cannot be allowed to be frustrated at the last minute by legal shenanigans. Jacob Zuma has always said, I want my day in court. What we're trying to do is to give him his day in court.
This has been a really, really long matter, dating back to 2003 when Bulelani Ngcuka made the announcement that the NPA will be prosecuting Schabir Shaik, but not Jacob Zuma, but said that there is a prima facie case against Jacob Zuma. And even looking back at that decision, do you think that at that time Bulelani Ngcuka should have taken the decision to say, let's prosecute both of them, let's prosecute the co-accused?
Well, it was entirely right. He should have prosecuted both, because if there is a corrupt relationship, it involves two people. It doesn't involve just one person. That would have saved a lot of time, a lot of trouble. It would have made a legal sense at the time, and we're really surprised that he didn't do that. This is the consequence of him not doing so.
And we're still facing that at the moment. And I was saying earlier on, and actually tweeted this, that I counted last night that at least 7 heads of the NPA and DPPs and some of them acting, have been faced with this matter of President Jacob Zuma, the corruption charges, from the corruption charges, then to the spy tapes. And if you look at the first portion, the first phase of this case, there was a willingness to prosecute, putting aside Bulelani Ngcuka's decision, there was a willingness to prosecute from Vusi Pikoli as well as Mr. And 2009, the Supreme Court of Appeal makes the decision that, listen, Jacob Zuma should face these charges. The NPA is correct in prosecuting him. And 8 years later, we have a situation where the NPA is in President Jacob Zuma's corner, somebody who they believed a couple of years ago should face corruption charges. And even the lead prosecutor at the time, Downer, still believed that President Jacob Zuma should have his day in court.
Yes. Well, it's a completely bizarre situation as you've outlined it. But at issue here is a very simple thing. Nobody is ever disputing that there was a case, it was a good case, it should have been prosecuted. The only issue at stake was the timing of the indictment, whether it was before Polokwane or after Polokwane. And even then, the National Prosecuting Authority at the time decided it should be served after Polokwane. It was served after Polokwane. So I can't see what prejudice anybody is suffering. The charges were good then, they're good now. The charges must go ahead.
Even Deputy Judge President Lidwaba stated in his judgment that he doesn't understand what link there has been made, that there could have been political interference in this case, considering that the decision was made, even by Bridget Mabandla, who advised that, listen, rather have the indictment served after the Polokwane conference. How do you then draw the inference that Leonard McCarthy was trying to influence the outcome of the Polokwane conference at the time?
Yes, well, I think we all know what the real reason was for the dropping of the charges at the time. President Zuma was about to become president of South Africa. The election was around the corner. The National Prosecuting Authority had a political problem. It needed to deal with that political problem. It invented judicial reasons for a political problem that it had. And our case is based on the fact that those were political reasons that were advanced, not legal reasons.
Because even Lidwaba goes further and he says that he doesn't understand when on the 31st of March 2009, the NPA still felt strong. This is the prosecution team, as well as Mkoterimshe, that there is a case against President Jacob Zuma and he should have his day in court. There was also the permanent stay application that President Jacob Zuma had filed for, and they still believe that he should face his day in court. What happened 24 hours later, on the 1st of April, when Mkoterimshe then decides to then make this decision to not prosecute President Jacob Zuma and drop the charges, and he makes the inference, this is now Judge Lidwaba, that there was some sort of pressure on Mkoterimshe?
Well, the ostensible reason was that he had spent the evening reading the intercepts, the so-called spy tapes, and that he was shocked and horrified and everything else of that nature. But I think that there's a much simpler explanation, and that is that he got a call from somebody who said, we can't carry on, we need to find a political solution to it, and the spy tapes presented at least a fig leaf of that political solution.
Well, certainly we'll have to wait and see how this case unfolds. 2 days have been set for oral arguments to be heard here in the Supreme Court of Appeal. And as James Selfe has said, and the DA has indicated before, that they're willing to fight this matter all the way heading up to the Constitutional Court. And of course, you'd remember that the NPA had before, immediately after the judgment, the North Gauteng High Court judgment, tried to appeal that matter at the Constitutional Court, but the Constitutional Court sent it back to them and said that they see no legal prospects in listening or hearing the matter at that time, considering some have interpreted that President Jacob Zuma has made this application here at the Supreme Court of Appeal. It's back to you in studio, Leanne.
All right.